Hi, I'm Christy Blatchford, courts columnist for the National Post and Post Media. And as some of you may know, I've been covering the trial of Joshua Boyle in Ottawa. He's the ex-Afghan hostage who is charged with 19 offenses, including 2 counts of sexual assault with a weapon, most of them allegedly committed against his former wife, Caitlin Coleman, estranged wife now, and all of them allegedly occurring after Coleman and Boyle returned to Canada after 5 years in captivity in Afghanistan. They returned in the fall of 2017. So Mr. Boyle's trial began some time ago, and it's now on an extended hiatus. It was delayed recently, not for any of the usual meeting and reasons. Courts are notorious for going off the rails. Somebody can fall sick, a witness can't come on time, there's no courtroom, it goes on and on. But this time the delay, which will be probably at least until July, that's the optimistic estimate, is caused because Coleman, the complainant in the case, the alleged victim in the case, and her lawyer are contesting what's called a 276 application successfully made by Boyle's lawyer. I'm going to try and simplify this because it's legally dense and I'm dense, so the combination can be fatal. I don't know that I completely get it, and let alone that I can completely translate it for everyone else. But basically, in the fall of 2018, the Liberal government, under then Attorney General Jody Wilson-Raybould, introduced, and this was passed in December of 2018, some changes to the sexual assault rape shield law. One of those changes gives automatic standing to complainants like Coleman, complainants in sex assault cases, when certain matters under Section 276 of the Criminal Code are raised under the so-called rape shield law. The rape shield laws prevent complainants from being questioned unduly about previous sexual contact or conduct and guard their privacy rights better. And now they have an automatic right to standing in the hearings that determine whether or not some of their records will be produced for the court and whether or not they'll have to answer certain kinds of questions. So anyway, that's the legal reason, and it's not all entirely new. What's new is this amendment, which gives complainants like Coleman in sex assault cases the automatic right to be represented by their own lawyer and for that lawyer to have official status at the hearing. The trial judge in this case, in the Boyle case, Peter Doody, had made a ruling following the multiple times amended 276 procedure. He'd made a successful application. It's a 2-step process, and one part of it is secret. I love secret justice. He succeeded, and he won the right to ask in cross-examination Coleman certain questions about previous sexual activity with Joshua Boyle. At that point, Coleman's lawyer said, I'm going to consult with my client. He asked for a brief break. He came back and said that he was going to seek an appeal of that ruling, and that's what's caused the delay. He appeared the following week in he will appear in Superior Court. He filed an application, and the application itself to appeal this thing has the immediate effect of staying or suspending the trial. So it now appears that the lawyer and Coleman are not going to take this all the way to if necessary, to the Ontario Court of Appeal, etc. So probably the trial will be back on the rails July sometime. The parties are going to argue this motion in May, and in June, perhaps, the judge, whoever it is, will give a decision. The larger question, though, is, should a third party to a criminal justice proceeding, any third party, have the right to derail a proceeding which is traditionally, historically, always seen as between the state and the accused? That's why in Canada, such trials are called Regina versus Blatchford, say R.V. Blatchford. I'm the accused, Regina is the state or the queen. In America, of course, it's the state of New York versus Harvey Weinstein, or the state of New York versus Christy Blatchford. It's meant to tell you that you have the full right to defend yourself against the charges that have been laid against you. And normally these are not interfered with, either the rights or the proceeding, a trial. To avail yourself of those rights is not to be interfered with by anybody but the state or you. And yet here we have a case where a trial has been delayed for, it will probably be 3 or 4 months before it gets back in court. In the interim, of course, the accused, who is a presumptively innocent man, is paying, I think, almost $700 a month out of his own pocket for an electronic ankle monitoring bracelet. He's not had any access to his children since he was first arrested, and he has to live at the age of 35 with his parents. So these have significant impacts. Anyway, that's it for me.